On the record in cause number 2020 CR 3647, the state of Texas versus Silvestre Alarcon. Attorneys, please make your announcement.
Madeline Flosser for the state.
Linda Corley for defense.
For purposes of the record, Mr. Alarcon is appearing by video conference. Mr. Alarcon, go ahead and state your full name for the record, sir.
Silvestre Alarcon.
Thank you. And you can hear me, correct?
Yes, Your Honor.
I'm going to be showing you some documents on the screen. If you could please take a look at the screen. Before I show you this one, I'm going to show you a different document. Hang on. Okay, I want to review the indictment with you, Mr. Alarcon. The true bill of indictment alleges the offense of driving while intoxicated, third or more offense. And it also alleges a prior felony conviction for driving while intoxicated in cause number 2008 CR 7598. So this is what we call a repeater paragraph. And so what it does is that it does affect the range of punishment. Ordinarily, Mr. Alarcon, the range of punishment for a third-degree DWI felony is anywhere from 2 to 10 years in the Texas Department of Criminal Justice and up to a $10,000 fine. So today it appears that, are we proceeding on the repeater paragraph as well, State?
We are, Your Honor.
Okay. So let me show you the court admonishments, Mr. Alarcon. Can you see that?
Yes, Your Honor.
Hang on. All right, so the range of punishment for a DWI third or more as a repeater is actually a second-degree felony. It is punishable anywhere from 2 to 20 years in the Texas Department of Criminal Justice Institutional Division and up to a $10,000 fine. Do you understand the range of punishment that applies to your charge, Mr. Alarcon?
Yes, Your Honor.
Okay, it's explained to you in that document that I was screen sharing with you, the court admonishments. Did you go over that with your attorney?
Yes, Your Honor.
Do you understand everything that is contained in this document?
Yes, Your Honor.
Okay, let's go over your constitutional rights. You have the right to a jury trial on this charge. You also have the right to cross-examine all the witnesses against you, and you have the right to remain silent. Those are your constitutional rights. Do you understand that?
Yes, Your Honor.
When you sign this document, what you're telling me is you want to give up those rights we just went over. Is that what you intend to do?
Yes, Your Honor.
Is this your signature that I'm showing you?
Yes, Your Honor.
Okay. And are you a citizen of the United States?
Yes, Your Honor.
If you were not a citizen of the United States, I'm still required to tell you that a plea of guilty or no contest to this charge could result in deportation, exclusion from admission to the country, or denial of naturalization under federal law. Are you satisfied with the representation of your attorney?
Yes, Your Honor.
Ms. Corley, does your client have a rational and a factual understanding of the proceedings against him?
I believe he does, Your Honor.
Has he been able to assist you in the preparation of any defenses?
Yes, Your Honor.
In your opinion, is he mentally competent to waive his rights and enter into a plea?
Yes, Your Honor. I haven't seen any evidence otherwise.
I will accept the waiver of rights and make it part of the record. Mr. Alarcon, let's go over the plea bargain agreement in this case. The plea bargain agreement calls for punishment to be assessed at a cap of 8 years in the Texas Department of Criminal Justice Institutional Division. The state will remain silent on your application for probation. Okay, and if the state is requesting that if the court grants probation, that all the normal DWI conditions apply. Is that your understanding of the plea bargain agreement?
Yes, Your Honor.
Is that yours, Ms. Corley?
It is, Your Honor.
State, is that your plea bargain agreement?
It is, Your Honor.
So to the charge of DWI, third or more offense, what is your plea? Guilty, not guilty, or no contest?
No contest, Your Honor.
Are you pleading no contest because you've talked about this matter with your attorney and you believe that this is in your best interest?
Yes, Your Honor.
And are you doing this freely and voluntarily?
Yes, Your Honor.
Anyone force you to enter a plea of no contest today?
No, Your Honor.
Has anyone offered you anything in exchange for your plea?
No, Your Honor.
I will accept the plea of no contest. I find it's voluntarily made, and I will ask the state to tender its proof.
Your Honor, at this time, the state would offer what has been previously tendered as States 1. In addition, while we started this plea, because the paperwork had to be redone, I don't believe that I attached his priors. So it did include it in an email that I sent to you, Ms. Corley, and both of the clerk's accounts. So the state would offer States 1 and in addition, the attachment in that email.
No objections, Your Honor.
States 1 is admitted. Give me a minute to review the attachment. Ms. Corley, are you satisfied the state complied with Article 3914 in this case?
They've given me everything I know of, Your Honor.
I do find that the evidence is sufficient to substantiate your guilt. Mr. Alarcon, if you could take a look at the screen on the repeat and offender enhancement allegation. I'm going to read that to you, and then I want you to tell me if it's true or not true. Are you the same Sylvester Alarcon that in cause number 2008 CR 7598 in Bexar County, Texas, was convicted of the offense of driving while intoxicated, third or more, on June 8th, 2009? Is that true or not true?
It is true, Your Honor.
Okay. I did find the evidence is sufficient, but I'm not going to make any other findings at this time. We're going to reset this for a TAP evaluation and a PSI. Ms. Corley, is there any need to do any testing on mental health issues, or are we good with TAP?
I think we're okay, Your Honor. I don't think we need any mental health testing.
Okay, with that, we're going to go off the record. You're going to get